Okay, I have 9:03, so I think we'll get started. Good morning, everybody. My name is Tom Pico, and I'm the President and CEO for the Penobscot Bay Regional Chamber of Commerce. And we're thrilled to have you all here. We have about 50 people registered this morning, so definitely an important and timely topic on Maine's new earned paid leave law. And we appreciate Eaton Peabody being our sponsor and presenting this morning. Before we dive into today's topic, I just have a couple of quick items to share from the Chamber. First, I want to, as we do with every event, thank our premium members for their additional support of the Chamber. And those include LCI, Machias Savings Bank, Eaton Peabody, and Ballou and Associates. So we thank them for being premium members of the Chamber. We hope you have a chance to visit our Chamber website at camdenrockland.com and check out the Keep the Cheer Here button there, which is a listing of a number of local businesses where you can do your holiday shopping. And we certainly from the Chamber are encouraging people to shop local and support our local businesses every holiday season, but especially this year in the midst of the pandemic. We want to make sure that we support our local businesses who really need us right now. So if you are a business that might like to be listed there, whether you're a member of the Chamber or not, if you're local in the Camden-Rockland region, then you can go there and list your business as well and share with folks what you're doing for holiday giving ideas. So check that out. And I want to remind you that we are in the midst of putting together an addendum to our current edition of the Jewel of the Maine Coast Guide. That will be an insert into the current edition. We have, as you might imagine, didn't go through quite as many copies of our regional guide as we normally do in 2020. So we're going to continue to use that and publish a smaller companion piece to go along with it for 2021, which includes some advertising opportunities too. So you could reach out to Diane Norton in our office if you want to talk about how that publication is coming together. So let's move into our topic for today. We are recording today's session and we'll share it later so that those who are unable to attend live can get the information. If you happen to have any questions while the session is going on, you can just post them in the chat and I'll manage asking questions from the group once Rebecca's presentation is complete, along with a few questions that some businesses have submitted to me in advance. So as you know, last year the Maine legislature passed and Governor Mills signed into law a new law that requires most businesses with over 10 employees to provide paid leave to employees that meet certain thresholds. So this law takes effect on January 1, and so that's why we wanted to bring this to you at this time so that people can be up to date on what the requirements are. We're pleased this morning to be joined by Rebecca LaPierre, who will be our presenter on this topic. Rebecca is an associate in Eaton Peabody's Employment and Labor Practice Group based in Bangor. Rebecca graduated magna cum laude from the University of Maine School of Law, where she was the online editor of the Ocean and Coastal Law Journal and president of the Student Bar Association. Rebecca has been a presenter with us before and does a great job, and we're looking forward to hearing from her again on this topic. So Rebecca, I'm going to turn it over to you.
Well, thank you very much, Tom, and thanks everyone for joining us this morning. I hope everyone is super excited to do some employment law at 9 a.m. like I get to do every day. It's going to be an interesting one. This law has a lot of layers to it. It's been very confusing for a lot of employers and a lot of businesses. If you're feeling confused about it, you are definitely not alone. It's taken a lot of time for us to kind of work through the Department of Labor's rules and their guidance and their frequently asked questions and try and figure out what it is that's going on here and what the best way to implement this is, especially for businesses that may already have a really robust paid leave program, but that doesn't necessarily comply with this law. So I'm going to address those topics today. I'm going to talk to you a little bit about just the general provisions of the law and whether or not you might need a new policy, whether or not or what the best option for a new policy might be for your business. I am very happy to take questions. I can't promise I know the answer to all of them. And if it's too specific, I can't necessarily give you legal advice, but I do welcome you to email me separately, and we can look into more specific issues if that's the case. So I'm going to attempt to share my screen right now, and we will see how that goes. So give me one moment. All right, can everyone see themselves? There we go. All righty. So Tom, I'm just gonna check in with you, make sure that the screen share is working properly on
Yes,
your.
indeed.
All righty. All right, so earned paid leave. It's a new law, like Tom said. It's going into effect on January 1st, so it's going to come up on us really quickly here. If you haven't taken a look at your policies or really looked into this law, now is the time to do it. If you haven't had your handbook reviewed or your policies generally reviewed lately at all, I'd say it's a great time to update everything. So feel free to reach out if you need help reviewing those. In terms of this law, the basics are if you're a business with 10 or more employees throughout the calendar year, you will probably be covered by this law. And who's going to be entitled to earn paid leave? Which employees are going to get it? Well, the answer is most of them. Almost every employee is going to be entitled to earn paid leave under the law. There are very, very limited exceptions, and those are for seasonal employees, but it's not seasonal in the sense that, oh, they just come work for me for the summer, or it's just an intern. It's a very specific definition of seasonal in terms of it being certain industries for certain periods of time, and the employer has to actually be a certified seasonal with the Unemployment Bureau. So we'll get into that a little bit more later, but don't get too excited about the seasonal exception unless you fit into a very specific category. Generally, your full-time, your part-time, per diem, temporary, everyone is going to be covered by this law. They are all going to be entitled to start accruing some paid leave. And so if you're not offering paid leave to anybody beyond your full-time regular employees, then you're going to have to amend something. And even if you are offering leave, you might still have to make some changes. A good rule of thumb in terms of determining whether or not you think your employees should be covered, the Department of Labor has essentially said if you list an employee on your quarterly report to the Bureau of Unemployment Compensation, that employee is going to be covered by the earned paid leave law. So when does it go into effect? As we've said a few times now, it's going into effect on January 1st. I can't believe 2020 is almost over. I'm not unhappy about 2020 being almost over. So hopefully 2021 is going to be a great year for us, even if you have to work on updating your policies and complying with this new law. If you are a lot of employers, this is the most common question I've been getting. If we are currently offering more than 40 hours of paid leave, do I have to do anything? Do I have to change my policy? Is my policy going to be okay because I already offer more than that? Well, maybe, but probably not. There are very few policies that I have seen from employers that adequately comply with every provision of this law, unless you were already offering some sort of open-ended PTO that employees could use for any reason, which there are some employers doing that, and in which case you might be all set. So I'm going to talk briefly about that seasonal employee exception again. The Department of Labor has offered a really helpful step-by-step guide in terms of determining if your employees will qualify as seasonal. There's also a list of the seasonal industries online. If you're not sure if your employees qualify, if you're not sure how to answer all of these questions on the list, about whether or not you're defined as seasonal, whether or not you are considered to employ more than 10 employees for more than 120 days of the year, if you're not sure if you're in a seasonal industry or if you've reported to the Bureau of Unemployment Compensation, that's something we could look at with you, and we're more than happy to do that. And you can also just give a call to the Bureau of Unemployment Compensation and see how they have you listed and how they have your business listed. So that's something you're going to want to go through step by step. If you think you might have seasonal employees, it's going to be a very, very limited exception. So only certain businesses are going to actually see this exemption apply. The next limited exception is for student employees, and these are again going to be in very specific circumstances. It's going to be in situations where that employee would not be covered by unemployment insurance. So that same basic rule of thumb is going to apply. If they are listed as an employee for purposes of unemployment insurance, then they are probably going to be covered by this law. But certain students, so if a student, for instance, is doing on-the-job training that's part of their school curriculum, or maybe they're getting credit for it, then those circumstances might exempt that employee from being covered by paid leave. So if you're a school, a university, a college, and you're having students who are enrolled at your school working at the school, then those student employees might not be covered. So this is the number one question of, do we need to change our policy? And I'm going to tell you in advance, you probably do. And I'm sorry to say that I'm giving a lot of bad news lately, but you are probably going to have to change your policy unless you have been giving a very generous and very flexible leave policy to your employees. So some questions you're going to want to think about here are, is your company providing paid leave for employees who aren't full-time? So what about the part-time employees? What about the per diem or the temporary employees? If you're not providing paid leave for them, we're going to have to update your policy. Are you permitting use of your paid leave before or after 120 days of employment? Do you have a probationary period? And is that probationary period longer than 120 days? If so, you're going to have to change your policy, because this leave must be permitted to be used after the employee has worked for 120 days. Do you currently front load your paid leave or accrue leave at a rate that is equal to or greater than 1 hour of accrued leave for every 40 hours worked? 1 hour for every 40 hours work is the minimum standard for this law. If you are accruing at a slower rate, it's not going to comply. If you are front loading, it will comply. If they're getting it right at the beginning of the year, you don't need to worry about accruing. If they are accruing it though, and you're accruing it, say 1 hour every month of work, that's not going to be sufficient to comply. All right, are you offering leave that could be used for any reason, or are you designating the leave to be specifically for sick time versus vacation time or bereavement leave, things like that? If you're designating your leave as separate categories, that's fine, generally speaking, but it doesn't comply with this law, which means you're going to have to make some edits either to make it comply with this law or to adapt in some way so that you have some other leave that complies with this law. Are you requiring more than 4 weeks of notice to request leave? In that case, you will have to change something as well, because this law only allows us to require up to 4 weeks of notice. So if you're requiring, that folks submit their vacation requests a month or 2 months in advance, I personally haven't seen that in anyone's policies, but if you are, then that's something that's not going to comply with this law. Are you permitting employees to use leave in cases of emergencies, illness, or sudden necessities without any advance notice? If you're not permitting that, if we're not allowing paid leave on a moment's notice because the car broke down or the baby's sick or whatever, then we're going to need to work on those policies, because this law requires us to permit this leave to be used in that way. Are you requiring documentation to support requests for leave? And this law has restrictions on that. So if you are requesting a doctor's note anytime someone is getting sick or calling out sick, that's not going to comply with this leave law. And you're going to have to permit some leave where you don't ask for a doctor's note, even if it's a last minute illness. The only time this law permits us to ask for documentation, or especially medical documentation, is if the employee has actually been out for 3 consecutive work days. After that, you can request documentation, and that would comply with FMLA concerns as well, if you're thinking about that. And then, are you disciplining employees? Do you have a point-based system where if employees use up so many points of leave that they'll be subject to discipline? Are employees going to be disciplined if they take too many days off? That's not going to comply with this law. You have to permit that any accrued leave that the employee has under this law be permitted to be used and cannot be disciplined for using that leave. And lastly, are you permitting the accrued leave to roll over from year to year? This is a bit of a tricky one for this law because it rolls over, but you can't accrue beyond 40 hours each year. So it's kind of a limited effect. But if we're not permitting the accrued leave to roll over, then that's something we're going to have to look at. So if you've looked at any of these questions and thought, oh yeah, we do that, or oh, that's not something we've thought about, then you're probably going to have to update your policy. So what options do you have? And this was one of the questions that was submitted earlier, and it's a question we've gotten from a lot of employers throughout the state. How do we do it? What are we doing? We already have this great, robust employee leave program. I don't know what to do. I don't know how to make this work. You have a few options. So the first option is that you can adapt your current leave policy to fully comply with this law, which would mean that you just make all the leave that you're already offering compliant with the law so that it can be used at any time for any reason, that it's within the notice requirements, within permitting the use of the leave for emergency leave. And I will say that a lot of employers don't want to do this because they offer substantial amounts of leave and they don't want to necessarily have to worry that someone's going to be calling in on an emergency basis every other day because they have so much leave available. So I understand that that's not necessarily the best option to a lot of employers, but if you have, if you're only offering 40 hours of leave right now for all employees, then maybe it's easier just to adapt what you've got already. The second option is that you adapt a portion of your current leave. So say you have a sick leave and a vacation leave separate provisions within your policy. You could adapt just one of those. So you could say, turn your sick leave policy into your earned paid leave policy, make that bucket of leave comply with the law and leave your vacation leave policy alone. So that's an option too. Another option is that you leave your current policies alone and you add a new policy for the earned paid leave. This is a good option if, say, you have good policies for your full-time employees and your full-time employees fully comply, but you don't have anything for your part-time per diem temp employees, then maybe you want to leave what complies for your full-time employees alone, but add just a small bucket of leave for those other employees that fully complies with this law. Or maybe you just really like your program and you don't mind giving some extra leave to employees. That's fine too. If you just want to add on to what you already got, you can do that, but you don't have to. You don't have to necessarily give something additional here. So the final category, and what we've been recommending most to employers and what we find is sort of easiest to work in this law with existing policies, is to add a new category of leave that is a specific category of leave just for this earned paid leave law that complies fully with the law, and then reduce the amount of time that you've been offering in one of your other categories of leave. So say you're currently offering 80 hours of sick leave a year and 80 hours of vacation leave. What you can do is you can keep your 80 hours of vacation leave and then reduce your sick leave offering to 40 hours, and then take that other 40 hours of sick leave you've already been offering and just amend it so that it fits with this earned paid leave law. And we found that that is generally the easiest way for employers to make this work, is to kind of reduce their leave. Oh, we're getting a visit from my dog. I'm sorry. So we're going to reduce a section of the leave so that we can make a new section of leave that will comply with the law in full. And it kind of simplifies things a little bit because you don't really have to mess with your other policies. You don't have to worry about trying to change how you apply or how you let employees use that leave. You just have to reduce one section and then create a separate section that fully complies. And to give you an idea of what that would look like, I have a sample policy for earned paid leave here on the screen. This sample policy is going to give you the absolute basics, the what you have to offer for the earned paid leave. And so it's going to permit the employees to have up to 40 hours of leave accrue and at the necessary rate of accrual, and to use the leave when they have to be allowed to use it. So to get into some of those specifics, I'll walk you through it a little bit. And I want to note that this is just a sample. You don't have to have a policy that looks like this. Some of the things in this policy are adaptable. Some of them are strictly in line with the law, and others, can be amended, or they're only meeting the minimum amounts of the law. So if you want to do something that's more generous, you can do that as well. So first of all, the first thing you're going to note is all eligible employees. And now we're going to want to keep that language in there because we want to make sure that the employees know that some employees may not be eligible. They're rare exceptions, but we want to keep that in there. I have split this sample policy up into non-exempt and exempt employees because the way you calculate the hours of accrual is going to be a little different for those employees. So what I've put here is I've said all eligible non-exempt employees will accrue earned paid leave. We've called it that just to kind of go in line with the law. You can call it PTO, you can call it paid time off. It doesn't really matter. At the rate of 1 hour of paid leave for every 40 hours worked. That's the minimum standard, is that the employees be able to get 1 hour accrued paid leave for every 40 hours they work. If you have a part-time employee who doesn't work 40 hours in a week, you can wait until that employee has worked 40 hours to accrue their 1 hour of leave. The minimum standard is that they receive 1 hour of accrued leave for every 40 hours that they work. For a full-time employee, that's easier because they're going to work 40 hours a week. Every week they're going to get 1 hour. It's pretty straightforward. For a part-time employee, it might take a while for them to get 40 hours built up. What I found for payroll purposes, in terms of keeping things in line, it's a lot easier to have the part-time employees accrue at a prorated rate in their pay period. And that's going to be, so you can just set it up that each pay period they're going to accrue based on how many hours they actually worked at a prorated rate of whatever 1 hour for 40 hours is. So if they did 20 hours, they're going to get a half an hour accrued. That's just my suggestion. That is not required under the law. Under the law, you just have to get them 1 hour accrued for every 40 hours worked. So you can wait until they've actually worked 40 hours to accrue that 1 hour of leave. Whatever works for you, for your payroll systems, for your accounting systems, is fine as long as they are meeting that minimum of 1 hour for every 40 hours worked. So like I said, I put in that we would offer a prorated rate for employees who work fewer hours than 40 per pay period, but that's a business choice for you. Next, like I said, I split up the exempt and the non-exempt employees. The Department of Labor has indicated that exempt employees, so salaried employees who are maybe working fluctuating hours from week to week, are going to be presumed to work 40 hours a week. That means that they are presumed to get 1 hour of paid leave for every week that they work. If you have full-time employees who work less than 40 hours a week or significantly more than 40 hours a week, and you would like them to accrue more accurately than that presumed 40 hours, you can do so, but you need to make sure you're tracking their hours. And most employers aren't tracking hours for a salaried exempt employee. If you happen to be tracking hours for salaried exempt employees, then you can be very specific with how much paid leave they're going to accrue. Or you can choose to start keeping track of their hours if you'd like. So the next part of the policy is that the earned paid leave will begin to accrue on January 1st, 2021, or at the start of employment, whichever comes later. What's going to happen here is that employees must begin to accrue earned paid leave from the moment they start working. They can't necessarily use it from the moment they start working, but from that very first day that they're working and they're clocked in and they're making money, they need to be accruing paid leave. So those hours, that first week of work, are all counting towards their accrual rate. Again, this doesn't start till January 1st. So if you currently have employees that are working on January 1st, they're going to start accruing this leave. Everyone else that starts working after January 1st, they're going to start accruing as soon as they start working. Employees may use earned paid leave beginning on January 1st or after 120 calendar days of employment with the employer, whichever comes later. employees must be permitted to use their earned paid leave that they have accrued after they have been employed for 120 calendar days. So if an employee has already worked for you for more than 120 calendar days on January 1st and they start accruing leave, they are permitted to use that leave immediately. So if they have worked for you for 2 years, January 1st, they start accruing this leave. January 7th, they want to use their 1 hour that they've accrued, they can. If they have not worked for you for 120 days, then they have to continue working for 120 days before they can use it. And again, this is going to be employer discretion. If you want to permit them to use it right away, you can. If you want to wait the 120 days, you can. But you can't require a longer probationary period than that 120 days.
Rebecca, just to clarify, you're talking, it's 120 calendar days, not that they've worked 120 days.
Yes, they haven't been, they've been on your
Employed
payroll
for
book
4
for
months.
120 calendar days.
Right.
Yeah.
Thank
So they don't actually have to come to work 120 days. They just have to, so say January 1st, they start working for you. There's going to be a lot of days off in there, but 120 days after January 1st, they are going to be able to use that leave.
Great, thank you.
You're welcome. All right, so in terms of using the leave, we have to permit employees to use this leave for any reason. And this is where a lot of the existing policies start to get difficult, because current policies usually separate vacation leave and sick leave, or bereavement leave, or leave for jury duty. This law requires us that we permit this particular leave to be used for any reason. We're not really allowed to ask why. We can get very limited. We can ask, but we can only ask for sort of limited, basic explanations of what they're using the leave for. So we have to be very flexible with this leave, which is part of why a lot of employers are choosing to kind of create a separate bucket of leave just for this law, because it is so flexible, and it's really advantageous for your employees. If your employees are worried they're losing something, they're really gaining something. So we have to permit this leave to be used for any reason. If it's a foreseeable reason, employee wants to take a vacation, employee's got a birthday coming up, employee's kid has a birthday coming up, that we can require advance notice for, and we can deny that leave if there is undue hardship on the business. If the employee has an emergency, an illness, some sort of sudden necessity that is a legitimate cause that they need to be out of work, and that could be anything that comes up. Their car broke down, they woke up feeling sick, they got in an accident, their mom showed up unexpectedly and is sick. I don't know. It could be anything that is a sudden necessity. And we're going to have to permit them to take accrued leave if they have it available in that emergency event. So for the foreseeable leave, we can require up to 4 weeks of notice. For emergency related leave, and emergency, illness, and sudden necessity are defined very broadly in the law. In those instances, we can only require notice as soon as practicable, meaning that if, the employee got in a car accident and their phone broke in the accident, and they don't get a chance to contact us until, halfway through the day because it just was not practicable for them to do so, we can't discipline them for that. If they had accrued leave available, we have to kind of let them use the accrued leave for that period of time, as long as they've notified us as soon as they were able to. If they get in a car accident and their phone's working just fine and they just choose not to call us, and they don't call for another day or two without showing up, that's a different story. But if they are contacting us as soon as practicable, or as soon as feasible, then they are going to be permitted to use leave if they have it available. It's very key to remember that they have to have the accrued leave available to them. They have to be eligible to use it, meaning they've worked that 120, or they've been employed for 120 calendar days, and they have the accrued leave available for them to use. That's the only way that they're going to be protected by this. At the end of the calendar year, we will have to roll over unused earned paid leave. This gets a little confusing because employees are only entitled to earn up to 40 hours of leave per year. Again, you can be more generous than that if you'd like to, but the rollover is going to count towards next year's total. So say an employee has 20 hours of leave accrued that they don't use in 2021, and then it rolls over to 2022. So they start 2022 with 20 hours in their bank already. They're only going to be able to accrue another 20 hours for that 2022 year because they've already got 20 hours. So it's not that they're going to roll over their 20 hours and then accrue another 40 hours on top of that, unless you want to let them. And that's going to be a choice for the business. But what the law requires is that we have that 40 hours per year available, and that whatever isn't used gets rolled over to the next year, and that rollover will count towards next year's total that the employee can accrue. Accrued but unused EPL, I put in brackets here, will or won't be paid out at the time of separation from employment. The DOL has indicated that this is going to be linked to your vacation policy. So if you have a vacation policy that you pay out, probably going to have to pay out on your unpaid leave at the time of separation. If you don't pay out your vacation, you don't have to pay out the unpaid leave either. So the Department of Labor has indicated that they should be sort of linked to each other, whatever your vacation policy is. If your policy is silent, if you don't have anything, then the earned paid leave is definitely going to reflect whatever your vacation policy is. So if you don't have anything in your earned paid leave policy about whether or not you're paying it out at the end of the year, whatever your vacation policy says is going to apply. And then I did include a little caveat here that requests for foreseeable leave may be denied in the event that permitting leave will result in an undue hardship on the employer. You're going to want to include that caveat there, sort of a catch-all, and there is a legal definition for an undue hardship. So it's not just, I didn't want to give it to you. It has to have an actual effect on the business to not permit the leave. Other things you might want to consider to include in your policy is if you have particular times of year or days of the year that are really busy for your business. If you have, say you're a retail business and the weeks before Christmas are just madness and you cannot afford to have everybody taking leave, then you can restrict foreseeable requests for leave during that period. So, vacations, birthdays, things like that. Emergencies are still going to need to be permitted if the employee has the accrued paid leave, but you can restrict certain times of year from employees making requests for foreseeable leave based on your business's needs. I included a slide here about the rates of pay. I'm not going to get deeply into this because it's going to be very fact specific for each of your employees, but generally speaking, the earned paid leave has to be paid out at the regular rate of pay, which is the base rate of pay for the employees. Department of Labor has provided a lot of guidance on how to calculate that. If you need help calculating that, we can absolutely take a look at that for you, or provide you with the formulas from Department of Labor. But there are different rules for, if an employee is a commission-based employee, if a per diem employee is paid based on certain rates of pay or certain types of pay per day. If it's a tip-based employee, it's going to be calculated a little differently. It's usually going to be the minimum wage. So that's what you're going to actually pay out for the earned paid leave. So when the employee uses their earned paid leave, the amount that you pay them, if you have a standard hourly employee who never gets bonuses, who never gets commissions, who doesn't get tips, who is, consistently always works the exact same hourly rate, that's easy to figure out. If you have an employee who's a tip-based employee or a commission-based employee or an employee who gets a lot of non-discretionary bonuses, that might be a little trickier to figure out what their base rate of pay is going to be. So some common questions that I have been asked in the last couple months are, what about union employees? Well, collective bargaining agreements that are currently in effect will remain in effect, do not need to be changed if they are in effect as of January 1st. So if you have a collective bargaining agreement that's going to expire next June, it's fine. Don't touch it, leave it alone. When you go to renegotiate the next time that collective bargaining agreement expires, it will have to comply with the law. So at that point, you're going to want to consider adjusting and working with the union to figure out how we can apply this law to the collective bargaining agreements, paid leave policies. But if it's currently in effect through or past January 1st, sorry, then you don't have to touch it until it expires and until you start negotiating the next agreement. Do we have to pay earned paid leave upon termination from employment? We discussed this briefly already. If it's kind of going to depend on what your vacation leave policy is. I also should note that if you do not pay out earned paid leave at the time of termination, then an employee who returns to work within 1 year is still entitled to the accrued leave that they had accrued before they left. So whenever an employee leaves, if you're not paying out that earned paid leave that they have accrued, you're going to want to keep track of how much they had, because if they come back to work for you within the next year, they're still entitled to that same leave that they'd already accrued. What if an employee is terminated from employment before 120 days have gone by? Same rules apply. If they leave and you don't pay it out, then you have to hold on to it for them if they return to work within 1 year. If they leave and your policy is to pay out earned paid leave, even if they haven't worked the 120 days to use their earned paid leave, you do have to still pay out that accrued paid leave. When can you deny a request for leave? Well, I kind of touched on this a little bit already as well. You can put in your policy that there are certain times of year where you will not accept foreseeable requests for leave, and you can deny if there is an undue hardship, which I'll get into a little bit more detailed in a minute. What if I have a busy season? Again, we just touched on that. If you have a busy season or days of the year that it would not be possible for you to permit leave, you can include that in your policy and you can restrict requests for leave during that period. Can you front load the earned paid leave at the beginning of the year instead of accruing it? Absolutely. If you don't want to worry about accrual rates, if you'd rather just have it available at the beginning of the year, every year on January 1st, they get 40 hours to use. End of story. Go ahead and do that. That's perfectly fine. What about salaried or exempt employees who don't track their time? I touched on this briefly. It's presumed that they will work 40 hours a week. They will therefore be presumed to accrue 1 hour of paid leave per week. If you don't want to follow that presumed period or that presumed 40 hours, you must actually track their hours or have some sort of an equivalent tracking program. So for instance, with adjunct professors, the DOL has said that if the employer uses the IRS rate of recording the hours worked for adjuncts professors who don't necessarily work regular hours, that would be an acceptable equivalent for tracking their time. And then do we have to base our policy on the calendar year? No, you do not. It could be the calendar year. It could be the employee's anniversary of hiring. It could be your fiscal year. It's totally up to you, as long as you just clearly define what that 1 year frame is. So the year in which they're going to accrue their 40 hours and the year in which they have to use that 40 hours. That could be from the day they're hired. It could be from January 1st. So somebody who's hired in September, is only going to be accruing from September till January, and then you'll start over. Or someone who's hired in September, you can start accruing in September and they'll accrue through the year until the following September when they have their anniversary. Or again, you can use your fiscal year as well. So some other helpful notes from the Maine DOL frequently asked questions. And I want to note that Maine DOL has supplied a lot of information on their website. They have specific frequently asked questions for municipalities. They have a detailed frequently asked questions. They've got the rules, they've got the law, they've got the poster. It's all on there. It's a lot to sort through. If you don't understand something, please feel free to email me. I'm more than happy to try and figure it out with you. But they do have a lot of resources on there. So undue hardship, when you can deny leave. They have defined that as a significant impact on the operation of the business or significant expenses considering the financial resources of the employer, the size of the workforce, and the nature of the industry. What this means is it is very fact specific. So depending on your business needs, your financial status, your operational needs, that's going to completely change what is considered an undue hardship for the purposes of denying a request for leave. You know, if you've only got 15 employees, so you're just barely covered by this law, and you've already had 3 employees request to be out and you can't operate without the other 12, then you could start denying leave at that point because you wouldn't be able to operate without them, and that would be an undue hardship. Requiring use of accrued leave. You can require that the employee use their accrued leave if they have it available, if they are out due to an emergency, illness, or sudden necessity. The times you couldn't require it would be as if they were out of work because we closed the business down due to a snow day, or we closed because of the pandemic and we have to be closed for a week. So you can't force them to use their earned paid leave if it's the business's decision to be closed. But if the employee needs to be out sick, or if the employee, you know, says, I want to take Friday off to go to the park with my kids, then those situations you can say, okay, but you're going to have to use your accrued earned paid leave. You can require the use of earned paid leave in 1 hour increments. The 1 hour increments are the minimum that you must permit. So if an employee says, my car broke down and I'm going to be 2 hours late, they can use those 2 hours of earned paid leave if they have it accrued for that morning. But if you want to permit them to use smaller increments, you can, but you don't have to. So you can't require them to, you know, take a full day. You have to permit at least the 1 hour increments. But if you choose to, you can also permit a half an hour or 45 minutes of leave if you'd like to. That's entirely an employer decision, as long as you are permitting at least the minimum 1 hour. Accrual rates. The minimum standard, as I've said, is 1 hour for every 40 hours worked, and accruing up to 40 hours per year. It is at the discretion of the employer if they will permit the accrual in smaller increments. So when I was saying that we could prorate for a part-time employee, what that means is you could have the part-time employee accruing a half an hour of leave for every 20 hours of work, while a full-time employee is working 40 hours a week and getting a full hour. So you can, if you choose to, permit the smaller accrual rate. So they could accrue based on their pay period versus how long it takes them to complete 40 hours of work. And if that's confusing, feel free to reach out. I'm more than happy to kind of slow it down and talk it through. Employees may not be disciplined for appropriately using EPL. So that's what you want to remember, is if the employees are appropriately using it, as in they're following your notice requirements, then you can't discipline them for using their accrued paid leave. However, you may discipline an employee if the employee is exceeding the amount of accrued paid leave that they have, or they aren't complying with your notice requirements. So if they're, you know, demanding to take earned paid leave and they're saying it's an emergency because you denied their request to go on vacation, that's different than if they, you know, you're just saying you've taken too many days off and now you're going to be disciplined. I do want to note that you may permit employees to exceed their amount of accrued leave, and you can also permit that you know, allow them to use leave they haven't accrued yet, and deduct that later as they accrue it. But that's, again, going to be a business decision of if that's something you want to permit or not. The last slide I've got on here before I'm hoping to get some questions from you all is the poster requirement. So DOL does have a earned paid leave poster that they are requiring employers to share with their employees. Recognizing that a lot of employees are working remotely right now, the DOL did specifically note that a business can meet the requirement by making the poster available on their intranet. If you don't have an intranet, generally, you know, sending emails out to everyone is probably going to be fine, as long as you make sure that all of the employees have seen and have available access to this poster. If you have any employees coming to a physical location at all, then that poster needs to be posted physically in a space where the employees will see it. I have a picture of the poster on here. It's free on Maine DOL's website, along with all of those frequently asked questions and guidance that they have provided for this law. So that's all I have in terms of my PowerPoint presentation. There are a lot of little details that go with this law, so I'm sure you have some questions. Tom, I'll hand it over to you.
Super. Yeah, I have had some questions in the chat and some submitted in advance. So let's start with, I had a question about businesses that might offer some sort of an incentive program for perfect attendance. And if, the requirement to allow emergency time off might, impact that.
Yeah, so that's a tricky one. There's a lot of businesses offer attendance bonuses. It's not necessarily the same as disciplining, because it's more of a, they could get a bonus versus they are being disciplined for taking the leave. So it's usually going to be okay to permit that, to have that, in order to encourage employees not to take time off. I will say that we have encouraged some employers to make exceptions to those bonus programs or policies, particularly with regard to COVID-19, because you don't want employees showing up sick and causing an outbreak. So we have advised some employers to just make exceptions due to our current pandemic situation. But in terms of the earned paid leave law, I am not aware of anything that would make an attendance bonus a problem to apply to this law.
Okay. So can you touched on briefly, but had somebody wanted you to clarify and just dive a little deeper. If, let's say you hired somebody today, but so they've worked part of those 120 days before January 1. How do you manage that? You don't have to start the clock ticking on the 120 days until January 1, is that correct?
No, the clock would start as soon as they start working, but if they haven't worked 120 days as of January 1, they're not going to be eligible until they have, or they haven't been employed, rather. They don't actually have to work 120 days, but if they haven't been on your payroll books and, as an employee for 120 days, they need to complete that 120 days, no matter what their first day of work was, whether their first day of work was before January or after January. They have to be employed for 120 days. So if you hired them today, I'm not great at math, so I don't know what 120 days is from today.
Yeah.
But
Middle of April, say, yeah.
Whatever that date is from
Right.
today would be when they can start using
Right.
their leave.
And if you hired them back in July, let's say, then the 120 days is up, even though the law doesn't start until January 1.
That's right. And if they've been working for you for 5 years, they've definitely worked their 120 days. So January 1, they're eligible to use it as soon as it's accrued.
Gotcha. Okay. So let's see, here's the next question. If we already gave employees PTO in July of 2020 and they will not receive more until July of 2021, can we look back to 2020?
Again, that's going to depend on what you're looking at for your calendar year. If your fiscal year is July to June, and that's when you offer leave for that 1 year period, that's fine. You don't have to necessarily add more leave to that, but it depends on if the leave you've already offered complied with the law. If the leave you offered in July did not comply with the law, you're going to have to change it and update it for January 1st.
Next one is, if an employee took earned paid leave that they had not accrued yet and then leave employment, how would you handle that?
So there is a very rare instance where you can deduct from an employee paycheck, and if for instance they owe you time off, then on their very last paycheck, I believe you can deduct the amount that they that they had used, but you can't deduct more than what their paycheck is. So if they took a week off and their paycheck isn't enough, their final paycheck isn't enough, then you just kind of lose out a little bit. But there is a rare instance where you are allowed to deduct from an employee paycheck, and it's in their final paycheck specifically.
Okay. So the next one, the employer front loads their new hires to have leave on their date of hire. However, everyone accrues through the year and is given that accrual on July 1 annually. So do they now have to give some of this accrual into 2021?
I think that would be a policy I would need to look at more closely because it's hard to say based on just the description. It would really, because it's going to depend on all of the factors of how that leave that's offered is applied. It's not just the amount of leave that's offered, it's the way in which the leave is permitted to be used as well.
Yep. So the next one was about an employee that has a no-fault attendance policy. They get points for unscheduled PTO or do not if they don't have available time. So even if a point doesn't result in a warning, is a point considered discipline?
It could
Um,
be.
yeah, okay,
Yeah, those point systems are going to be tough. You're probably going to want to make a separate leave category for this leave that doesn't affect the points,
yep,
because if ultimately they end up being disciplined because they had so many points built up, because so if they've got 40 hours, they could use up to 5 days of emergency leave, right? And if you're going to get a point for each of those 5 days and 5 points ends up resulting in discipline, then that's going to be a problem.
sure. Can you talk about how profit sharing might impact calculating the rate of pay for this?
Um, it shouldn't.
Okay,
But I'm not, I would have to check the FLSA rules on how profit sharing goes into the rate of pay, but I don't believe profit sharing applies to the regular rate of pay. But I would want to double check on that. So if that person is more seriously concerned, I would say send me an email and I can look into it.
okay. Any suggestions on tracking existing PTO versus earned paid leave? If you're already providing adequate PTO, they're just unclear about how to distinguish between the two or if they need to.
So if you have PTO, if you have a general PTO category, you don't require it to be used for any certain reason, and it's in excess of the 40 hours required, it's in excess of the accrual rate, and the way you require the leave to be used, you might not need to change anything. That's the rare occasion where you're going to be all set because you already have a bucket of leave that can be used for any reason and that already complies with the rules in the law. But you're going to want to be careful to make sure that the rule that your policy for using the leave does in fact fully comply, because even though you've got enough leave and you're allowing it for any reason, if you're requiring too much notice or you're not permitting the emergency leave, then you might still run into some problems. Or if you're not having it roll over, things like that, you're going to want to make sure that you're complying with all of those factors as well.
Right. Can an employee use earned paid leave as part of a 2-week notice if they're leaving?
Probably.
Yeah.
It's gonna depend on the facts. If they have the accrued leave though, and they've requested it in compliance with your notice requirements, then I can't imagine why not. But if they are just not showing up for their last 2 weeks, that's going to be different.
Right. Okay. Um, just a question about increments of time. If an employee, shows up 5 minutes late because they had a flat tire, they got stuck in traffic, they woke up late, can they consider that use the time because it was a sudden necessity?
So sort of, in terms of if it's only 5 minutes late, that like I said, the minimum that the law requires us to permit is 1 hour increments. So you could say you're 5 minutes late, you're gonna have to use 1 hour of earned paid leave. But that probably isn't necessarily worth you paying them for an hour for them to be 5 minutes late. Um, if they request it, you might have to permit it. Like if they call and say, I got a flat tire and I'm going to be late, I'd like to use earned paid leave. Then you're going to have to permit that even if they end up showing up 20 minutes later and it wasn't a full hour. In terms of allowing them to use it to cover just 5 minutes, that's your choice. You don't have to provide them with 5 minutes of earned paid leave. But if they request to use an hour because of because of a breakdown or a flat tire, then you do have to permit the minimum of the 1 hour increments.
Okay. We had another question submitted in advance about statutory employees that take raw materials home, bring back finished goods, and are paid for their work. So they're not, that for the federal government, they withhold Social Security and Medicare, but not federal taxes, and don't pay federal unemployment, but they do pay state unemployment, which I think you had said, basically, if you are paying state unemployment, they probably qualify. So does this category of a statutory employee fit into this?
Yeah, so I saw that question. I don't, in terms of, I'm going to say I believe that these employees would still be covered because it's a state law and they're covered by state unemployment. They're probably going to be covered by this law. It's a very specific question, a very specific type of employee, so it might be something that's worth looking into a little bit more in depth. But generally speaking, if you're paying state unemployment insurance for them, then they are going to be covered.
Okay. And a couple others that were submitted in advance along the same theme about sort of tracking. If your program already includes all of the elements of the earned paid leave law, plus it's more robust than what the state requires, then you don't necessarily have to change anything. As long as you're already meeting all of those requirements, you can continue with your current plan. Is that true?
Yep, that's right. So if you truly comply with every element of this law and you comply with the amount of leave and the rates that must be provided, and you're providing it to every employee, not just the full-time employees, then you won't have to change anything. If you genuinely already comply with the law, with what you provide currently, you don't have to add additional leave. It's not necessarily new leave that must be made available. It's just that the leave that you're offering has to fully comply.
Okay. Just to close, I wanted to revisit the seasonal industries thing, because we do have a lot of seasonal businesses in our area, as obviously, but don't necessarily assume because you see the words seasonal industries that you qualify, right? I mean, it definitely, you want to dig into that further and understand what qualifies and whether you're truly registered with the state. I think you said as a seasonal business, right? So
Yeah.
um,
Yep. So there's a specific list of seasonal industries that's available on Maine Department of Labor, so you can see if you qualify. But depending on the type of position, there's different seasonal periods. So the employee has to work in that type of position within the seasonal period, and you have to be registered with the state as to have those as seasonal employees.
right.
So, in terms of, I know there's a lot of hotels and inns and seasonal restaurants and things like that. Some of those are going to be permitted, and in fact, Department of Labor says that those are to be determined on an individual basis in terms of what their seasonal period would be. So you have a little bit more flexibility than, say, if you were in the blueberry harvesting field, then those are really, really set dates. But so if you're not sure, it's definitely something that's worth looking into. If you haven't registered as a seasonal business with the state, this is probably the time to do it.
Right.
So I would definitely check that list, see if you fit, and then contact the department and see if it's something that they can work with you on.
Rebecca LaPierre from Eaton Peabody, thank you very much for spending this hour with us. A lot of great information, and we appreciate it. I know our members that were tuning in and those that were tuning in do as well. So thanks. We'll be posting the recording of this session too for those who are unable to tune in live. So thanks, everybody. Have a great day.
Thanks.